One last hearing, it seems, from Miss Sarah. This is unbelievable with this lady. Let's try something here. Come on. Good morning, guys. Oh, she loves it. She loves the attention. She is something else altogether, I promise. I've never seen anybody like Sarah. Never. Never. My goodness gracious. I don't know. How much longer can we do this? How much longer? I don't know. Forever, it feels like. It just feels like it's just not going to stop with her. She's just got to keep pushing and pushing and pushing until somebody goes crazy. She did have some great clothes on yesterday, though. I'll give her that. She was looking pretty good. Pretty slick. Let me see. I need to replace my thumbnail. I didn't really think about that before I came live, just because I was really hoping we were going to have a trial today. But I don't even think the jury has even been seated. Okay. What? How? How is this taking so long? She is just, she wants 5 peppermints and what the hell are you even, what? She needs to have 5 peppermints, guys, and some other things that she needs to have, like a Pop-Tart. Oh, Sarah. Oh, Sarah. But they did get her hair done. They did, she was looking cool in the green shirt there. So, yeah, I think she thinks she's going free. Man, I'm guessing she goes, the trial starts tomorrow. I wish I had a great answer on that. It feels like we're never going to get a proper answer. But I do know they did let people into the courthouse right now. So there are people in there. They are waiting. And there's yet another motions hearing. Motions hearing on what? What in the world could be what? Please, okay? I don't know. But we're going to tune in and we're going to see what exactly it is that she needs now. But I know that yesterday with the friggin' things that she needed, I just watched it in case you guys didn't see it. It was pretty funny. The stuff that she wanted. Her poor attorney, man, must be like, what? And I know, he's doing the best that he can, but where is this one? I just watched it. Oh, she was looking decent yesterday. Here we go. Hold on. Here she is. Here's Miss Sarah. Look at her. Fixing her jacket up. Some muted tones, yeah. Mm-hmm. She looks good. No, she does not want a fancy lunch. That is the funniest part. She does not want a fancy lunch. She wants like, look at Sarah. Sarah. She wants Pop-Tarts and some other things. Hold on, I'll show you. The things that she wants are nothing that I would ask for. I guess what she gets in the basement. Here you go. Hold on.
I fell asleep.
That's not it. Here it is.
Over. Of course, it had to be turned into the Sarah Boone show.
She's asking for.
I got to make sure you guys can hear it. Hold on. Let me know if you can hear it.
2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart to allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement at lunch, but she's not diagnosed with any kind of blood sugar, but she says she gets like today. She's feeling tired and lethargic, and so she feels like those items during a break, that she could have something like that to keep her energy level.
I will speak to the captain of the jail if I can get a hold of her before 5 o'clock tonight and see what, if anything, we can do. I can't make any promises. My understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are provided for Ms. Boone. That's for all inmates that are stored downstairs during trials.
And before the end of the day was over, of course, it had to be turned into the Sarah Boone show.
She's asking for 2 juice packs, 5 peppermints, 2 bags of chips.
This attorney, look, he's like, what the fuck are we doing? I don't know, man. Oh, goodness gracious. Sarah, 5 peppermints, not some peppermints, not a pack of peppermints, not 10 peppermints, 5 peppermints. Okay, just 5. That's it. That's all. That's what she needs. That's what we're gonna do here, and it's the end of it. That's it. Okay. She is so interesting. She is so interesting. Here she goes. I mean, they, excuse little mama in the background with her snuffleupagus-ness. Georgia, seriously, I can't. I absolutely can't with her. She got real shoes, which was great. Yeah, she makes a mockery out of everything. She did this in her interviews with the police, the interrogations, where she said, I would never do this. I'm good at everything. I excel at everything. I left, enough open for his finger to get out. You could open it with one finger. Then there was the paper clip. Then, he's never done anything, to make me want to do this, except then you hear about the cheating. And she's like, well, we were just playing. We were painting. We were doing puzzles in the things. I mean, does anybody believe any of this? Any of it? Any of it? Yellow Skittles. I can't. Straight A's. She got straight A's, okay? Straight A's. She excels at everything that she does. I've got to wonder what prison has been like for her at this point. You have to wonder how in the world. I don't even think they're done picking the jury. I don't even think, Jennifer Coffindaffer. I don't think, porn, because, the porn people got to get in on this as well, of course. So, 14 hours. Sarah Boone jury selection continued today. She was in a grayish blazer coat and green shirt. Black shoes, not jail slides. Jury selection is paused tomorrow, which is Wednesday, for a pre-trial hearing. So they paused jury selection because there's yet another hearing. She never stops. She truly doesn't stop. Morning, Chris. She thought she was smarter than all of her lawyers, definitely. Oh, Lindsay, girl, she was feeling herself, okay? She was looking great. I don't even know. I don't even know. Sarah. Let's see. Why are you trying to get me to pay for Twitter? Get out of here, please. Okay, yep. The jury has not been chosen. They paused for yet another hearing. So that's where we are with it. Until whenever. And if they're still questioning the jury, we're not going to be able to be in the courtroom, clearly. I mean, they're not going to allow that. So we'll just listen to whatever it is that they're going to let us listen to today, I guess. This is so crazy. Let's see. I'm just waiting for it to start. She'll have to DoorDash for lunch. Yeah, no. She'll be eating the peanut butter sandwiches in the basement. She absolutely should have taken the deal. I think this is, I don't know now, Pixie. You have me questioning myself. Is this her 8th or 9th lawyer? I don't know. I want to say it's number 8, but I think there are 2 of them. She is the female Daryl. She cycled through 8. So this is number 9. Yeah, it's the 9th one. It is the 9th one. Oh, Sarah. Because she lost the 8th one. The 8th one, I remember watching that hearing. The judge said, "It has become apparent to the court that the defendant will not permit herself to be represented by anyone." She said that her last lawyer is a liar and has a snotty attitude. Snotty. She says, "I feel she's untruthful with me and full-blown prejudiced against me. And this adds to her nasty attitude. I do not trust her. Everyone constantly blames me." Yes, she said constantly 3 times. "That I am the reason why I am supposedly going on attorney number 8, and I am not the reason for any of this. I know in the court's difficult position, but at this point, we're at the impasse of I just can't work with her." Oh, that was the day that she submitted a 58-page handwritten letter about the complaints of her case. Oh my goodness. I don't even know. Good morning. Imagine being her cellmate. No. Telling us the whole story of them painting and playing hide and go seek. It just was absolutely the most bizarre thing I'd ever heard. And I'm thinking, no adults are doing that. That did not happen. It's not happening. You're not being honest. Please stop. Why are you lying? I don't know. She's a wild one. Oh, baby, you're a wild one. Let me see if Fox 35 is covering it at all. Probably not. No. Doesn't look like it. My dogs are going to town on that bone over there. I think this attorney. Yeah. Maybe. I mean, I don't. How many of you have seen other morning Cammy, other people like Sarah? I don't know. I don't know. She signed her name on the last letter, the 58-page letter, with a hand-drawn heart, followed by the words, confused cat, meme. Yes, thank you. Are you... Okay, so it looked like heart, confused cat, meme. Yes, thank you. That's how she signed it. What does that even mean? You write the words out, confused cat meme? I don't know. Sarah, Miss Lady. I don't know. I've never seen, I mean, Daryl, yes. Cat Stevens. What's that mean? Yes, Cat Stevens. Are they in kindergarten? Yeah. I love Cat Stevens, so don't tell me anything crazy. What, that he used to play hide and seek? I mean, I could see maybe him doing that, sure. But not her. She got in trouble right before parole eligibility for giving an interview. She's just... I don't understand her. Oh, hopefully we're getting there. This is taking forever. The Delphi murders. What about that? What do you think about Delphi right now? Do you guys follow Delphi? Oh, my Lord. I'm going to share this while we're waiting for Miss Sarah. Delphi's wild.
Brian Buckmeyer joins me now for more on this. Brian, this case has been the center of attention not only in Delphi but across the country. Could that complicate jury selection?
Diane, it can complicate it in many ways, but I think what the court has done here in moving the case from Delphi, a community of about 3,000 people, to Allen County, they're hoping that that issue of finding a jury that's impartial and unbiased is alleviated by this move.
So how much of a role do you think this audio that was recorded on Libby's phone will play in the trial, and what other evidence do you expect to see here?
Remember, they only released a little tiny part of what was on her phone. So we don't know what else she was able to record on that phone. There might be quite a bit more that implicates Richard Allen or somebody else. We don't know.
So I think a lot of internet sleuths and true crime aficionados will tell you that that video is everything for the prosecution. People, both in the case and outside, have scoured that video multiple times for any amount of clues, and I think the jury will do the same. But I think we're also going to hear evidence from that bullet, that unspent bullet that they found. We'll also hear from the defense of Ron Logan. That's the person who the two victims' bodies were discovered on, but actually passed away in January 2022. And he, in fact, through investigation, told a family member to lie about an alibi as to where he was at the exact time of those murders. So I expect the defense to bring that up in a case like this. And of course, a lot of the discovery we haven't heard as yet. So it's not just about what we have heard so far, but what we haven't heard so far that I think will really surprise us.
Now, prosecutors say prison recordings and communications reveal that Allen allegedly confessed to the crimes more than 60 times while in custody. The defense says those confessions were due to a decline in his mental health. The judge ruled they can still be used in court. So what do you make of that decision, and how damning is that for the defense?
I think for the judge, it makes sense to bring in those confessions. There are his own statements that are made voluntarily. They are saying that he made those statements to prison inmates, to a warden, to guards, to family members, to a psychiatrist. And so depending on how the circumstance is, they can come in, and it seems like there are. For the defense, hey, false confessions are difficult. 60 false confessions, if that's the view you're taking, is very difficult. But I think you attack it one confession at a time, and where there is a lack of corroboration. So for example, if Richard Allen says that he shot the victims, when we know know that they were stabbed, then you could take that and say, hey, he's just making up anything that he can to try to get out of something, or he has some sort of mental health issues that they're pointing to. So a lack of corroboration can help them with false confessions, but still, 60 confessions is a tough thing for any defense attorney to try to overcome in front of a jury.
ABC News legal contributor Brian Buckmeyer, thank you.
Yes. I knew that there were a bunch of people attending. I wasn't sure exactly who was going to Delphi. I knew that there were several people going from YouTube, especially me. I know that they also didn't have a huge line out there, which shocked me for Delphi. I know that they're not allowing a lot of people to be in there, and there are limited seats, allegedly. I don't know. Let me see here. Sarah Boone, one last time. Where the hell are you? Why is this taking so long? I don't understand. Let me see. I know that, was it Defense Diaries? Was it Defense Diaries who attended Delphi yesterday? I thought. Hold on. Yeah. The Defense Diaries did. They were there yesterday. Now it looks like they've moved this to 9:20, which is 20 more minutes. Oh my lord. This is unreal. Oh, there you go. Pix. Defense Diaries did. Yes, they did. Let's see here. What do you guys think about the hair? And I hate that this person is not allowing cameras. I hate that. This gull, evil wench. Let's see here. Also, the court will learn in this affidavit for search warrant that Sheriff Liggett failed to inform Judge Diener that nothing, absolutely nothing, links Richard Allen to Odinism or any other religious cult. Also, no forensics such as DNA. No electronic data extracted from his computers or phones or social media links Richard Allen to the crime scene. Additionally, nothing links Richard Allen to any of the Odinite suspects, the same Odinite suspects that evidence strongly supports sacrifice of Abby and Libby in some sort of pagan ritual. Richard Allen had nothing to do with this crime, but rather as an innocent man, a patsy for the police, arrested 26 days before an election. Tony Liggett has testified under oath that there is no DNA linking Richard Allen to the crime scene. Liggett further testified he is unaware of anything that links Richard to the crime through his phone, computer, or electronics. Liggett has further testified he is unaware of any evidence that links Richard Allen to any weird religious cult group. Jerry Holman has testified to the following. There is no DNA linking Richard Allen to the crime scene. No data extracted from his phone that connects him to these murders. No data extracted from Libby's phone connects Richard to the murders. There is no evidence that Richard Allen is or was connected to any of the suspects in the case. There is no evidence found on social media that connects Richard Allen to the murders. No evidence extracted from Richard Allen's computers that connect him to these murders. No fingerprint evidence. This person was just looking for DNA, the term DNA. So that's what they found there. Hoosier asked the question we all want to know. Did he?
Motherfucking hair is that? Whose motherfucking hair is that?
I don't know whose motherfucking hair that is, sir. I don't know. All right. Breaking. Richard Allen's defense attorneys say hair found in Abby Williams' hand does not match Richard Allen's DNA. So for them to say that they have the DNA is interesting, but it doesn't match Richard Allen's. If it matched Libby's, wouldn't they say it matched Libby? If it matched some other unknown person, wouldn't they say it matches an unknown person? I don't know. I mean, I don't know. They absolutely should have gotten a different judge. 1,000,000%. At this point, every single court case, absolutely. 1,000,000%. It should be. Like the gentleman, Robert Roberson, who is about to be put to death tomorrow. Yep, I saw Patricia. He's about to be put to death, and he very likely didn't commit the crime that they're putting him to death for. Very likely did not do it. Which is insane to me. How? How? Let me see here. Cat Williams. I love Cat Williams. This guy right here. This is such a terrible, sad story, and nobody gives a shit. Oh, so 10 hours ago, Dr. Phil interviews him. Really,
because I
bro?
want you
Yes, sir.
to have all the opportunity you can to say the things that are important to you.
Yes, sir.
And I'd just like for you to tell me what you can remember about what happened with Nikki on the night.
So for those of you who don't know, this little girl here is Nikki. This is her dad, Robert, the man that you're seeing on the phone with Dr. Phil. He was accused of shaken baby syndrome, which all the science for that ultimately has been debunked. They also said that he sexually molested her. It comes out years later that there was no evidence of any sexual molestation whatsoever. She died because she had like double pneumonia. She was a very sickly baby. He didn't know at the time and didn't know for 15 years after being convicted that he has autism. So his lack of appropriate emotion prevented him from even having the right conversations, answering properly. He was just, he didn't know what to do, which they found suspicious, of course.
That you took her to the emergency room.
First, we woke up. I heard a sound. Right. I woke up. I found her on the floor. So we stayed up for a while. I kept her up for a while. And she seemed like she was okay. But then I had my alarm set for like 9 o'clock in the morning. And when I had got up, she wasn't breathing, and her lips was blue. And then I got her to the hospital, and they was asking what happened. And I explained to them all that I knew. And just because I didn't know exactly what happened to her, because I found her on the floor, they thought I was guilty.
All right, so you woke up and found her on the floor at what time?
That was about 5. I think it was about 5 something when I heard her making those noises. She was on the floor. So and I left something out. I'm sorry about that, sir. I seen a little blood on her lip right there and stuff. I don't know if she hit her head or whatever, but a little blood. So I wiped it off with a washcloth. So when we was at the hospital, just because of the way I couldn't explain what happened to her, right? And they said I was distraught. Have you said that word, distraught or something? I wasn't acting right stuff. So they thought I was guilty. So they called the police and stuff in. And the police, they carried her back to the room back there. So the police said, could we go to your house, check it out? You know, I didn't mind, you know, because I didn't do nothing, you know. So we went to the house and stuff, and they're looking around. They didn't find no foul play or nothing.
Did someone take Nikki to the hospital the day before?
Yes, sir, I did.
You took her the day before?
Yes, and some days before that too, you know, to the doctor. We carried her to the...
But someone took her to the ER the day before this?
I believe so.
And was that you?
Yes, sir, yes, sir.
And what caused you to take her to the emergency room the day before?
Because something, I don't remember exactly, you know. She was sick and stuff, you know. But we had carried, because I carried a doctor in the hospital several different times back then. And then both of them had prescribed some medication, you know, like codeine and phenergan and stuff, you know, that you don't even get to, you're not even supposed to give children that young, you know. And
come to find out, she was sick. And they gave her medications that since that time we found out are very dangerous for kids, for babies that age. You're not supposed to give them, but they did. Now, the detective who was involved in his case has even gone to Governor Abbott. They've tried to get this all overturned. The appeals court refuses to hear it. Nobody will hear it. He's out of appeals. His only hope right now is Governor Abbott listening to this and stopping it.
I'm not sure at the time. I know her temperature was high. One time it was 103 point something, then another time it was 104 point something, you know.
But when you took her to the hospital the day before, that was you taking her just by yourself?
No, sir. Somebody had met me, you know. Somebody had went with me. I'm not sure which grandmother it was, you know, because one of them had went to the doctor with me, you know, and the other one had went to the hospital with me.
And it's been 21 years, so
yes,
I understand.
It's hard to remember.
I understand.
I'm just being honest with you.
And I appreciate that.
Yes,
and thank you for that. Just do the best you can with telling me. And so the day before, you had been to the doctor and to the hospital?
Yeah, I think the doctor was before that, was some days before that.
In the 2 years of her life, I believe she had 46 or 47 doctor visits in the 2 years. I have a chart that shows them.
I didn't know that, you know, because I hadn't studied that. I know she'd been sick since she was 8 days old, what I was told. I didn't know that at first when I first got her, you know.
Yeah. And how long had you had her in your care?
It was like November the year before, and this happened like, January 31st, I think. So it was November something. It was about December, about 2 months.
So you'd had her about maybe part of November, all of December, and then this happened in January.
Someone gave her to me because they thought the father, you know, since I'm the father, I should have a chance with her and stuff, to raise her and stuff, you know.
How'd you get along with Nikki?
At first, she was, you know, kind of scared because I somebody new, you know. But I was finally getting used to her. And if you could see some, I'm pretty sure you've probably seen some of the pictures. One of them I was on the Lincoln town car, yellow one, and another one I was over there holding her with some more kids sitting beside me and stuff, you know. And she started laying on my chest and stuff, you know, asleep sometimes. But that, on the Lincoln town car,
yeah, you're on the hood of the front of the Lincoln car.
And that's at the end of my mom's house out in the country out there.
Yeah. So you were getting comfortable with her, and she with you. And you said that you just had her in your custody for a couple of months.
Yes,
there.
sir. Yes, sir.
You're her father. Why was she not in your custody for the first 2 years of her life, the first 22 months?
You want me to be honest?
Yes.
I was locked up in prison before something I did do.
And what did you do? What do you do when you get angry?
Now or then?
Then.
That's a good question. Wrong crowd and stuff, and was doing drugs and alcohol back then and stuff, you know.
What kind of drugs were you doing?
We were doing marijuana, methamphetamine and stuff. We drank alcohol, sometimes a little bit of cocaine and stuff, you know.
The Whoville lady? Do you mean, what's her face? Leilani? Is that who you're talking about? Leilani's trial has been the slowest. So slow. So slow. It's been awful. It really, truly has been terrible. The way that they're dealing with it is, it's just been extremely slow. Can you guys stop? What are you doing down there? No. They're trying to pull out the what? Hold on. Stop. Oh my God. Stop. What do you need? If I could show you these lunatics, I would. Stop it. Oh my God. I think today's motion is going to be about not being able to use the for Sarah, for our friend Sarah, this battered spouse defense, which, I mean, she's entitled to a defense, right? So what can you do? You have to allow her to have a defense. There's not really a lot that we can do to stop that, I don't think, even though she never talked about that before. So they're having a bond hearing first. They brought in 2 other prisoners, and then they'll be moving to the jury box for Sarah Boone's motion trial. This is according to people who are in the courtroom. Let's see. Yeah, just tell us what is going on with that, because it's become crazy. Just what is going on? What did you do? But at the same time, let's see here. Battered spouse. Yeah, her attorney was shocked about the battered spouse. I mean, what? Really? That's what we're going with, huh? Okay. All right. And I mean, her attorney, how did he come up with that so fast? I mean, this is a brand new attorney that she has. So Lord knows what she provided him with, or how in the world it came to be that it was going to be the battered spouse, but that's where we are. So, all right, looks like this is going to start at 9:30. Good morning, Cat's Eye. How is she entitled to battered spouse? She's saying she didn't leave him there on purpose. Battered spouse is about defending yourself, isn't it? You would think so. You would think that that's exactly what it's supposed to be. Let's see. So, let's look at this really quickly. Oh, Tommy, shush. Shush, Tommy. Okay, so this is from 2023. As the murder trial approaches for defendant Sarah Boone, her defense attorneys have stated that their client will be using the battered spouse syndrome as a defense to her boyfriend's death in 2020. And this is a law office, so the article will provide details regarding the case, etc., etc. What is battered spouse syndrome? Despite some belief, battered spouse syndrome is a form of post-traumatic stress disorder rather than a mental illness. Battered spouse syndrome, previously referred to as battered woman syndrome, is a condition that is created by sustained physical, emotional, or sexual abuse from a partner that results in a variety of physical and emotional symptoms. Battered spouse syndrome is the result of beating, choking, sexual assault, verbal assault, physical indicators, black eye, bruises, broken bones, cuts, scratches, choking marks. A person accused of killing their spouse out of fear may suffer from battered spouse syndrome, which is created after a cycle of abuse within the couple's relationship. According to the Florida Bar, there are typically 3 phases. Phase 1, verbal abuse, minor battery incidents, attempts from the victim to placate the abuser. Phase 2, acute battery incident in which the spouse was severely beaten or bruised. Phase 3, displays of regretful and loving behavior to reinforce the victim's hope for their spouse's reform. The cycle's often ongoing, with phase 3 rotating back to phase 1 after a period of time. In these instances, the victim of abuse may feel helpless. Some may feel as that they have no option but to kill their abuser as a means of escape. According to NSU, there are 4 characteristics. The spouse believes the violence was their own fault. The spouse is incapable of placing the responsibility for the violence elsewhere. The spouse fears for his or her life. The spouse has the irrational belief that their abuser is all-knowing and at no fault. Based on how she spoke about him, I don't think any of this applies. I know that he has been arrested before for them getting into domestics, but also her too. So Orange County Police arrested Sarah, age 45 at the time. George was 42 after he died in the suitcase at the home. During the investigation, she said that they had been drinking wine and playing a game of hide and seek. After being too tired, she went to bed. The defendant woke up several hours later, hearing her phone ring. George was inside the zipped suitcase, where he was unresponsive and not breathing. Further inspection, her phone told on her, and her saying, "Yeah, that's what you do when you choke me. This is for everything that you've done to me." So, examples of battered spouse defense. 1994, Kathleen Wayland was accused of shooting her husband, which resulted in his death. Before this case, Florida followed the minority rule that the victim has the duty to retreat before choosing to defend themselves. The gray area in the case was, what if both the defendant and victim resided in the same home where the killing took place? So that is what she's going with. And I mean, we do know that they did have physical altercations, right? But that doesn't mean that that night something happened, because she didn't have any marks on her. You know, they did not. Hey, Melissa, there were no marks. And if there were, then it's up to her to show those. Also, you could say, hey, country, hey, BG, you could say maybe she was sobering up and she just wasn't able to formulate the words. But we see the conversations that she had with the police. There's no way you're not going to get away with that. You can't get away with that. There was nothing happening to you in that moment. Now, could they say, I guess, that maybe because he went in the suitcase and she thought it was funny to zip him up, that she was afraid that he was going to get mad and beat her? I don't know. Daryl Brooks. Yeah. Queen Bella. Good morning. This is taking 85,962 years to start. It is ridiculous. She absolutely mocked him as he died. She's quite the lady there, but she gets straight A's, just so you're aware. Okay, just don't even. She excels at everything that she does. You know. Let's see here. All right. Motion hearing. will not be posting this trial. You can stream it on Law and Crime. Okay. Let's see here. This has turned into a shit show. If you're not on X, you're missing out. You are missing out on things that happened. Okay? You are. And you should be there. Because I'm telling you, she did mock him. She was just, and they just let her talk. They already knew 100%. Hey, yep. It's a definite stretch. I'm trying to think, what in the world could she say to make this even sound believable as to where an attorney is going to take this and say, yeah, we can go with that defense. Sure. Uh-huh. Well, what the fuck? Sarah Boone will be wearing what the blonde woman is holding. Okay. Let's see here. Okay. So they're getting her clothes every day, new clothes. Very interesting. This lady is listed as the jury consultant for the defense. Motion hearing begins at 9:30 a.m. Okay. You can find out a lot on Twitter, on X. Oh, Sarah. 2 bags of chips, 5 peppermints, and a partridge in a pear tree. I don't know who Claire the Bear is.
I think it gets robot-y. And I just don't want the feed to come through,
I love her voice.
robot-y at all.
Claire Bear. Hey, Tater. Oh, she'll definitely testify. Put a 1 in the chat if Sarah is going to testify. Oh, she's going to testify. I don't think she can't. I don't think she could keep herself in line. There's not any way that this woman doesn't testify. This courtroom is set up very differently from any other courtroom I've been in. Judge Craddock looks different in person. Give me 1 sec. Hold on. Tommy is really whining quite a bit. Law News with a Z expands, acquiring trial live streaming forum court chatter. All right, let's see what Kathy has to say. Oh, the husband burned trial. That's been crazy. I've been watching that on and off too. Oh my God, Sarah, please. Can they really get it together? Got 5 minutes, bruh. 5 more minutes here. Let's see. This needs to come on. You've never been cool? Oh, you probably have. You just don't know it. You just don't know it. Let's watch the chat. What's going on over there? Why so many motion hearings? That's what we'd like to know. Sarah's stalling. I would say you're correct. Did I read she actually wants cookies in court? Yes. And everything that she wants is loud. So you want cookies, a Pop-Tart, chips, juice bags, or whatever the hell she said. Think about the distraction that is in court. Chips, cookies, they're all in foil bags. What the hell are you doing? You can't have any of that. You cannot have those things. I don't know. I mean, I guess being in prison, jail, whatever, it's probably horrible. And you don't get all the commissary stuff if you don't have people, helping. And I can't imagine, who would be helping Sarah? I don't know. I don't know. I can't imagine many would want to assist Miss Sarah. Because she is something. Pop-Tart crumbles everywhere. All right, Cammie, sweetie. It does sound like a kid's request, right? It sounds like something my son would ask for. I want chips and Pop-Tarts and juice and peppermints and cookies. What? She has a couple girlfriends in there. They're helping her. Okay. 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 Oreos and popcorn for real. Cookies are a food group. That's true. They are a food group. 4 minutes. 3 minutes. Lord have mercy. I really thought things would start today. Nope. Nope. When does the actual trial start? Probably tomorrow. Maybe Friday. The state got late discovered medical records. They're trying to get the judge not to allow the defendant to be able to allow to use them. Okay, put that sentence together. So, cookies, chips, Capri Suns, 5 mints, no more, no less. A vial of her attorney's tears. I cannot. A lock of the judge's hair. And friendship bracelet. I can't stand you. Don't you love those in the toaster? No, you can eat them like, regular. Oh, the beautification. I know. Oh. She's trying to put it off because she's guilty as hell. I think she's somebody with that personality where if she's not right, nobody's right. It isn't even that she knows that she did it and needs to move on. She knows she did this. She's crazy, sure, but not that crazy. She knows what she did. But I think she really enjoys the attention that she's getting from all these attorneys going back and forth to court. Remember during all of the different hearings, how many things she wanted? She was asking for paper, pencils, laptops, motions, briefings, evidence. She wanted everything. And now she just wants 5 peppermints. That's it. That's all. Sounds familiar. Raw Pop-Tarts are kind of gross, but hot Pop-Tarts will burn your damn face off. If they're too hot, the shit on top will kick your ass. Yeah, attention. She loves attention. She really does remind me somewhat of Daryl. Remember? Do you remember when Daryl was hiding behind the boxes? He built up all the boxes on his table. I know, Bama Cat. I'm hoping. Wouldn't that be something? Wouldn't that be something? If they did. Oh, of course, we say 9:30 and it's 10:45 or something by the time this shit comes on. This is crazy. Poor. I cannot. Me too. When he was hiding behind the boxes. That was my favorite. I'm like, what the fuck? He don't want nobody looking at him, man. Oh, that was the funniest ever. Oh. Objection. Grounds. Grounds. That's just a trial you could watch over and over and over again. I've never seen anything like him. Ever. Ever. You missed that trial? What? Stop. Oh my God. How? It was the trial. Listen. There was nothing better. He just kept building the boxes. It's like, ever. Wait. Hold on. I'll show you him. Here he is. So there's an order that the judge gives him, right? Oh my God.
Jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused for the evening. We'll see you tomorrow morning. All rise for the jurors, please.
Daryl did the craziest things ever. Ever. Hitting the shit. Okay? That judge was the best judge who ever was, okay? Because, wait.
Without having that letter.
So
the state has the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here. So, I may take an early lunch, and if that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear that just fine.
In a quiet courtroom, yes, we can hear it very clearly.
And everybody assumes that it has to be disparaging.
Once again, you're doing this tactic.
Because it's not a tactic. It's facts. It's facts.
To some other reason.
It's facts. Because I find it hard to believe that
I'm gonna
all of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you believe it's...
I didn't get these pictures from nobody else. Why was somebody else...
The record will reflect you have 2 pictures that you believe were from this witness.
That I know is from him.
No, that you believe.
That I know.
All right. I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to that.
Let the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada. And for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at
finish.
the end of the day,
Let him finish,
if we gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was when we met.
interrupting.
We can ask
He's-
that question
he is
too. Then
over the
Did you
top,
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what?
They kept putting him in the other room. He didn't give a fuck.
Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight.
Nobody was funnier than Daryl. I don't give a shit. Okay. So funny. I mean, what he did wasn't funny. None of that was funny at all. However, him defending himself was one of the best things I've ever seen. Oh my God. When is this going to start? Never. It's never going to start. Never. Just say never with me. It's never gonna start. Jesus Christmas. Oh my Lord. Oh my Lord. Please, Jesus. This is fucking taking too long. Tommy wants to go out and we're stuck here. We're stuck over here. They have it scheduled for tomorrow. They're not even... Thomas. Shut up. Shut up, Thomas. Oh my God. I'm going crazy. Why is somebody saying hi to Pixie? Pixie better not fucking be over there. That's a different Pixie. You're lucky, Pix. You almost got called out. Yeah. Sparker, so friggin' funny. Oh, never, ever, 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 ever. Oh. Maybe she's doing her makey. You know, getting ready with all the things. I can't. Oh, Sarah. My feed says waiting. Correct. Because we're waiting. You ever just sit and read some of the comments on YouTube? Some of the things that people say? Lord, it's a task. It's a lot. Anyone here following the Quentin Nixon case? Did they ever get a verdict? No. Duck donuts or Krispy Kreme? I don't know what a duck donut is. This isn't worth it. This is not worth it. Oh, she probably is doing her makey. Eating Pop-Tarts. Hanging out. Yeah, it's freezing here. Well, it was earlier. It's better now. Shortest jury deliberation in history. Quentin Simon, but not Quentin Nixon. Yeah. Oh, Jesus. This is... Her and the attorney are at Waffle House. Oh, God. He got on your nerves. This is ridiculous, bro. It's in the high 30s. Mother jeez. It was cold as shit this morning when I got up. I was like, what? I mean, I know it's fall turning into winter, but what was it when I got up this morning? It was freezing. For me, it was freezing. You know, I don't like the cold. Had to be 40-ish. They're saying it was like 48 this morning, but I think that's a lie. Craig. Tomorrow morning, the low is 37. I won't be having it. By Saturday, we are back up to 75. Oh, next Wednesday, 81. I don't know what I'm talking about. This week's cold, though. Just got to deal with it. I knew I shouldn't have even thought this would start on time. Serious. Sarah Boone. She hasn't entered yet. He is sentencing 3 prisoners that took a plea deal. That was 18 minutes ago. Can we even have a fall? 27. Lord God. I won't have it. No, ma'am. Look what you went and got. Are you kidding me right now? Twitter. She went and got the peppermints, the Pop-Tarts, the cookies, the juice boxes, all the things. Juice bags, pouch, juice pouch. Thomas. Oh my God, I gotta go let him out. He's mad. Try and get the best layout here that I can. Tommy, please, sir. Please, sir. He knows I'm in here talking. He hates that. He really hates that. Can you hear him? Gavel. Oh, that's cold. I'm not turning my heater on. I refuse it. Yeah, except it's just a hearing now. Gavel. Imagine. So annoying. So annoying. They paused jury selection for this. For her hearing. Friggin' loony bird. What's that? Dog pee? Oh. He already went out first thing in the morning when I get up. He's just mad now because the other 2 are in here. He's back in his room. and he wants to be in here, but him and Lola argue constantly. You cannot do a live stream when him and Lola are arguing. It doesn't work. And yesterday Lola got kicked out. Today Tommy gets kicked out because they can't be together. The jealousy is unreal. It's unreal, and they won't stop. I mean, while we're waiting, I might as well just run him down there again so he can go back outside and stop being a jealous little bastard. I'll be right back. And we're back and it still hasn't fucking started. This is ridiculous. Oh my gosh, come on, dude. This is taking forever. Delayed. No, I can't take it. I really tried. It is the slowest trial I've ever seen. I can't do it. I can't do it. I can't. Yep, still hasn't started. Okay. Let's check X and get an update. Nope. This is ridiculous. She should have. She 100% should have. Yeah, maybe. No updates. Oh my god, now the fucking cat. This house is psycho house, okay? That's all you hear is craziness. Gavel geeks. Now, I watched the full first day of Leilani. Then I watched part of what was going on yesterday off and on. His opening statement was really difficult. I don't know. I'm surprised Betty's not there. You know, Betty, the one who fucking loved him so much. Betty, who let all her rage out on them. What is Betty up to, the crazy bastard? Betty. Oh, she actually talked about him 34 minutes ago. Shocker. Hi, Betty. How are you?
They go to safety, right? Because
Here's
young
Betty.
children, they don't understand. They just know they don't need to be here. They need to be there. The yard right now, picking up the same phase. What do you think of them not testing as much stuff or wearing gloves? Like I said, you know, law enforcement makes mistakes in cases, and those mistakes cost. That's why I'm so critical of law enforcement in these cases. We understand that they do make mistakes, and it's going to always happen. And I'll tell you why. Because they're human, and there's not one human that I know. House, what are the feelings, you know, you get all that from being boots on the ground and being there personally. You don't get that from the screen because there's so much you've missed. You only get to see what's going on or what the judge will allow you to see online or on these like court TV or law and crime type of situations. But there's so much more that goes on that the cameras aren't allowed to get. Our children's life and our children's upbringing, that she's got 2 out of 3 children in jail for murder. That is an upbringing issue. The reason why her grandson is, and I blame Billy Joe for this. Now, I blame Leilani, but I blame Billy Joe more. And I hope Billy Joe pays for what she has done to her grandson.
And this reminds us why we hate her. Leilani was allowed to be around her son as long as she had supervision. Billy Joe had to work. Oh, Betty.
Because she went to court and fought to have that child removed from Leilani's custody, citing drug use and physical abuse. And the courts granted Billy Joe Howe custody of all the children. Of all the children. And she was just about to evict her daughter out of her house when this happened. The babysitter is the one that should have been watching those children, and she was supposed to be watching those children, and Billy Joe's told her to release those children into Leilani's custody. And within 24 hours, Quentin Simon was dead. Within 24 hours, Quentin Simon was dead. I blame Billy Joe. She had a duty to protect her grandchildren, and she gave
Within 24 hours? What?
gave them right back to the woman she just took custody away from, citing drug abuse and physical abuse. What Billy Joe has to deal with from this point forward, I do not care. I do not pity her. She is not a victim. This is her responsibility. This is her fault. Those children were protected, and she handed them to a beast. And she didn't care because she didn't think her daughter would do it.
Do you see the hate in her face? Do you see it? Look at this. Look.
And within 24 hours, Quentin Simon was dead. Within 24 hours, Quentin Simon was dead. I blame Billy Joe. She had a duty to protect her grandchildren, and she gave them right back to the woman she just took custody away from, citing drug abuse and physical abuse. What Billy Joe has to deal with from this point forward, I do not care. I do not pity her. She is not a victim. This is her responsibility. This is her fault. Those children were protected, and she handed them to a beast. And she didn't care because she didn't think her daughter would do it. Billy Joe will never have to pay the freedom consequence of her decision, but I hope she has the mental one that keeps her chained to her little pipe that she...
Betty, why are you so
likes to smoke.
Evil?
And shame on the county for not, in the Department of Children and Family Services in that county, not making sure that Leilani was away from those children. They allowed Leilani to lay her head next to those children.
Like, do you see how evil she is? She's just a mean human. Yeah, the pause game, right?
When she had already been, when the courts found there was abuse and drug use, and removed those children and put them in the custody of their grandmother. I'm not ashamed of what I did out there. We did it lawfully, we did it legally, and of course the hate channels came and turned it into a circus again, much like they're doing to the Sebastian Rogers case, by pointing the finger and saying, look what she's causing, talking about me, when I'm there advocating, and they're the one turning it into a circus. So, based upon what I've already seen, this is just the prosecution side. I think they've done a great job, even with not testing a few things. One thing about defense attorneys is they're going to shine a spotlight on things that are insignificant that could appear to be significant. So you didn't test the beer can. No, we tested the car. Well, if you didn't test the beer can, how are you going to know that somebody else wasn't in that car? Well, because their DNA would be in the rest of the car. You see that? They can't be in there drinking a beer can without touching the seat, without touching the door. Do you know that Hendersonville is being sued? Hendersonville Police Department, not Seminole County Sheriff's Office, but Hendersonville Police Department was being sued for excessive force. And guess what they cited as the reason for the dismissal? Not proper service.
Can we count together? The Gabby Petito case. Summer Wells case, Hawkins County. Quentin Simon's case, their sheriffs, their police departments. Hendersonville, Sumner County, all of it. Every time it's the police's fault, every time they did something wrong, she didn't do anything wrong. They did something wrong. And that's why everything is all screwed up, because of what they've done. All the police have done it wrong, and that's it. How's that even possible, Betty? How's it even possible? Don't worry, I'm checking on Sarah's case every couple of seconds here. Idaho 4 as well. I appreciate you texting. It's constant. It's constant with her.
Not proper service. Citing. And a federal judge agreed with them that you cannot advance a case without proper service. So not only that, but we have a very direct case that's going on inside that county right now that because of improper service, a federal judge dismissed the case. And so I'm sitting here scratching my head and saying, everybody in this town knew about this, including that judge, because I'm sure he reads the news. And it's described is that it was a camera outside of the Texas Roadhouse, and you could see them leaving and getting into the vehicle. So there was no doubt in anybody's mind that Sebastian, because I think that it did cross some people's minds, you know, could this have happened prior to? We've had the Elijah Vu case where it appeared that even though he was reported missing on February 20th, it appears that he lost his life on February 16th, because we were able to sleuth and we did find, through the help of some other people, we were able to find the last proof of life video for Elijah Vu going into the Napa Auto Parts store. And after that, there was no trace of him. So it was our belief early on in that case, which again we got right, that he didn't disappear on the 20th, but
Okay, so now she's got the Elijah case right. She's got Elijah's case right, right? Okay. Seven months ago, last sighting. It's right there. 6 months ago. So she did Elijah and Madeline together. Okay, so you've done a total on Elijah of, this is probably what, 20 minutes, 33 minutes, 1 minute, and 3 minutes. Ma'am, what? So, yeah, you did a lot in this case. A lot. And this isn't even about, the whole thing isn't even about Elijah. So, let's see.
We have proof of life for Elijah Vu on February 16th between 2:30 and 3:30, as observed in this video right here. I have been following the Elijah Vu case since the Amber Alert was released on this little boy. This little boy is a 3-year-old boy that disappeared on February 20th, according to his mother and the caretaker, Jesse Vang. He was last seen with Jesse Vang, alive, healthy, and walking February 16th. This is the last video of life that I can find. Here he is. This is Elijah Vu with Jesse Vang and only Jesse Vang in a store near Jesse Vang's apartment. Elijah Vu was last seen at Jesse Vang's apartment in Two Rivers, Wisconsin on February 20th, according to law enforcement. Since then, the search has went to a landfill. But I want you guys to see this. This is the heaviest presence we're learning right now that's underway for the 3-year-old that is missing. If you guys don't remember what is going on, Elijah Vu disappeared. The mom or Jesse Vang called it in. I think it was Jesse Vang that called it in on February 20th. And we knew really quickly that this wasn't as it seemed, because law enforcement almost immediately started asking for any footage and videography and photography and everything dating all the way back to February 12th, which many of us in the crime world know the only reason why they're looking back that far is because they don't believe the parent's story, whoever's calling them in and telling them. So we knew very quickly that there was something hinky going on. Well, it's been many weeks, and this 3-year-old hasn't been found. The mom, Katrina Bauer, and her boyfriend, Jesse Vang, are both behind bars on negligent charges. Nothing related to his disappearance, nothing related to anything else related to him other than the negligence that happened on what they said happened on February 14th and again on February 16th. So this is in my opinion, some major movement in this case, because again, this is the largest presence they've had of law enforcement, and I'm hearing that there's something like 54 drones, drone team in the area right now. They're deploying, law enforcement is deploying boats in this area. And you know, at first, because I thought it was just a coordinated volunteer effort. Thank you, Pumpkin. God bless you. I thought it was a volunteer effort, you know, because the family has had significant volunteers and significant presence in the area searching for Elijah. So I just thought that they moved into this area, but I'm finding out that's not true. This is law enforcement. This is law enforcement. This is law enforcement teams, and they're going out there. So my next question is whether or not this is the largest police presence they've had since he went missing, and they're saying yes. So I don't know what it means. I'm just letting you guys know. Keep our fingers crossed. The 3-year-old boy hasn't been found yet. We're hoping that he comes home safely, but with each passing day, we know that that's getting further and further away. They did find one of his dinosaur shoes and his blanket, the only things keeping him warm. So it's not really looking good, but we're going to continue to maintain hope, and hopefully there's a good resolution to this horrible story. I'll keep you posted. God bless.
So what exactly did she do in this case? Because she just said in the last case she was right. In the last video, right?
But I want you guys to see this. This is the...
Oh my God, it's here. Lord jeez, hold on. Finally.
part of this investigation.
Clearly, they don't have the sound on yet. Oh. I checked. There's no sound yet. She may have put that on at the jail. You know, they do their little homemade makeup stuff. Yeah, this is a very interesting looking little courtroom. Very small. So you've got these regular chairs back there behind them, and then a couple of benches. I'm on the long crime site too. There is no sound yet. They haven't turned it on yet. Let's hope so. I don't see, I mean, everything's streamed these days. I don't understand why nobody can get it right. Stand in front of the microphone so that people can hear you. It's crazy to me. I don't think she has a choice with this one now. Come on, where is the sound? No, she's not defending herself anymore. These guys have been defending her for a while. The guy with the white hair there. Makeup on in the court. It had to be off before returning. Oh, look at, get your water, girl. 2 cups of water. Here we go.
William J. for the state.
James Owens on behalf of Sarah Boone. Tony Henderson on behalf of Sarah Boone.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone,
10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force, filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same, also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th, and then the parties' objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So, State, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Kopsel and Lowen on February 24th, 2020, and February 25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes in as 1 for the purposes of this hearing.
Responses to what was pre-marked as A. All right, what was pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as states 3 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as states C will be received without objection as states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire. That was not the purpose of our motion. I don't think we mentioned voir dire. Because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now, preliminarily, is if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony was is, we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is, we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually, it comes to a point in time where they're sitting on the couch, and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out, and she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error, but this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we are asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we are asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence,
Go ahead, sir.
or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in, and her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
Good morning, Judge.
Good morning, sir.
I'm a little confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask, I'll ask a more of an open-ended question. What is the basis, factually, of Dr. Harper's opinion? So if we were at trial right now, for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told in outside sources too. They are able to make a determination based on their training and experience. So,
but based on the Akendo case, which is cited by the state as to what what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
Because, if you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal?
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I have cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog, and that bad dog bites, and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up, that triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know, based on the court's ruling, what your client has already said to Doctors Warner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Judge, could I respond?
Briefly.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
but the problem is in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
yes,
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
it's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this has put, this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning?
You want to mention an opening? You can mention an opening. Certainly I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire, and even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
My concern is opening. Can it be mentioned in the
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
I believe there's some state witnesses here. We would like to invoke.
Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Is there going to be testimony?
Not from the state.
You've got state witnesses here, you know?
She's allowed to be here to watch.
I understand, but I want to know whether she's going to testify.
I said there's no state witnesses.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir. I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she had recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases. I cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found. Do you need the cite?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant,
has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
The state stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about the
No, the words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when he says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion, where the Supreme Court is giving instructions to the court with those comments. For them not to put that in there, I disagree with it.
Okay, well, the Jackson case speaks for itself, and the court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion, as under the Bush case cited by the state, law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is the expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regards to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Judge, just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from 2 incidents, one in 2017 and one in 2018. A third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I have not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment. That narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the court right now.
That. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres' medical records prior to me sending them to you? No, we didn't. All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that. But they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be...
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony...
You are the proponent of the evidence.
Yes.
So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages I think the state identified as that, what of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since
Well,
we have some level of common ground here?
My case is not going to be presented, I would assume, until next week, so I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them. But in one of the medical records, George Torres was over a .31 BAC. Every time...
In 2018?
2018?
I'm talking about the 2018 incident with regard to the plate glass window.
I have to look at the records. But there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a .3. When he gets over a .2 to .3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, But Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find, based on that, whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be. Some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case, or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both. In the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torreses and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day, and that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance, so I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left, so I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay, all right. I need clarification, Mr. Owens, as to when the fifth amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed. We're checking on that. When it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and let me get
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. Okay. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3. That would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor. Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines?
Response.
I don't know the layout of 23, so
Can you all approach just for a second?
Don't be getting yourselves in trouble now. Okay? Oh, Sarah. What are we thinking so far? Oh, goodness. She is quite an interesting character. I think he's a very, very fair judge, though. He really is. And he definitely knows the law. She's not getting away with too much with him in the room. Sorry, I'm working on my other screens while I'm doing all of this. This one. Boop. Okay. Save. All right. Let me see if all of this is correct or not. She really should have taken the plea deal. Yeah, she really, really, really should have taken the plea deal. I don't know. I mean, she'd be getting out soon. She's already been in there forever. So I don't know what in the hell possessed her, but She thinks she knows better than anybody else. She really does. And I think that's what keeps getting her into trouble. It's her insistence that she knows better than anybody else on what to do and how to do it. You don't know.
All right, court's going to take a 15-minute recess to address jury selection location this afternoon, and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, if he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense? Correct. That is correct.
Anything in addition to how she was feeling?
I read you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank you.
They shall recess. All right, Rock. What's with the snack thing? She's hungry, clearly. I have no idea. She said that she gets very tired during the day. So, because she gets tired, she wanted to have some snackies. And I mean, I guess I understand. You're sitting there all day. It can probably get boring, but I mean, you're fighting for your life. There's not a lot she can do. You know, she's just sitting there mostly. So while people are testifying or whatever, I'm sure, you know, she wants something to do, like snackies. And also, you know, who knows what the hell they do all day in jail? And what really can they do besides eat? I don't know. Eat, sleep, gossip, I guess watch TV maybe, I don't know. I know in a lot of jails, like in Boston, way back, they were allowed to use tablets back then, and they were just coming out. So I would guess these days they really are pretty advanced with what they can do with technology in there, using it. I know, wasn't she asking for like, not an iPad, but definitely a laptop or something? I'm like, what do you think this is? It's not a hotel. But sleep all day, play cards at night, bread and water lady. Yeah, she wants all the things. Thank you, Fairy, for becoming a member. Sleep all day. That must be exciting, right? I don't know. I can't imagine that anything in there at all would be exciting ever. But and today we will be seeing whether or not the Menendez brothers are going to be able to at least be heard again. Maybe get another trial. I don't know. I don't feel like they're going to get another trial. Maybe they're going to reduce their sentence and let them out of there, allegedly. But I don't know. Let's see what's going on over in Leilani's trial. Anything? No. I hate to say this, but her attorney, oh my Lord. Not her attorney, the state's attorney. Let's flip it over this one for a second.
Your Honor, the state's put me on notice that they're going to attempt to get into some text messaging. It looks like beginning on or around September 25th of 2022 up to, and I don't want to put words in Mr. Dean's mouth, but it looks like through maybe day of October 4th, 2022, of an alleged affair between Miss Simon and an unknown subject by the name of Craig. And the text messages were provided in discovery, and they were part of the phone extraction, and they were done pursuant to the search warrant. If I'm making a misstatement, let me know, Tim. However, the main thing is the motion in limine I'm making is to exclude these text messages as they're more prejudicial than probative, number one. Number two, they don't relate to any material allegation in the indictment. None of the false statements accounts are in relation to these text messages. Number two and number three, I don't think that they do anything other than attempt to introduce her character, the evidence, and interject her character improperly. So for those reasons, I make a motion to exclude any testimony regarding these text messages back and forth between the unknown subject, Craig. So I think that's short, succinct, to the point. So.
All right. Thank you, Mr. Hilliard. Mr. Dean?
The court will remember that our motion pertaining to intrinsic evidence that we intended to introduce listed as one of those categories evidence of tension, unhappiness between the defendant and her boyfriend. And that has now been ruled admissible. This specific aspect of that, I think, is, I don't know that we explicitly addressed this on this past Thursday.
Yay.
But the original motion, part of it was, and this is in there, the court can look back, and things were so bad between the two of them that it pushed the defendant to commence a sexual relationship with her drug dealer as a form of solace in the weeks leading up to Quentin's disappearance. And this would be evidence of that. As Mr. Hilliard said, these text messages extend from September 25th to October 4th, so they're tightly connected in time to the day of the crime. And I'll talk just briefly about what they show. I have, as a matter of fact, I'll approach with what I've marked as State's Exhibit 83.
All right.
I have a
No. Which texts? I've been over here all morning doing this stuff. Were there texts or something? I mean, this is way behind, as you can see. Well, you can't really see it, but it is behind just because I clicked over while they were on break for Sarah. I have a very difficult time listening to the gentleman who was just talking. It's brutal.
Thank you.
Here's how it comes up naturally in this portion of Detective Lemon's investigation. At this point, we've just seen these interviews yesterday where she identified the drug dealer whom she saw that night as Red. Okay, she calls him Red. Sometime after that, but still, this is the night of October 5th, early morning hours of October 6th, they go through her phone in some more detail, and they find a bunch of text messages between her and a contact saved as Craig. And they ask her who Craig is, and she says Craig and Red are the same person. So she's identifying Craig now as her drug dealer, and not just any drug dealer, but the ones that she ran off to that night after getting into an argument with the defendant about about his lack of sexual desire for her. Okay, so this is the person that she's going to in response to that incident between her and Mr. Youngkin. And now, after opening statement, some of the evidence, I expect the court to be a little more familiar with our theory of the case and how what was going on with the Danny defendant relationship, how it plays into what happened that night. In these messages, one, they make out a recent sexual relationship, and I'll just draw the court to a couple messages in particular, so you don't have to read them all. On page 9, so page 9 of the document, starting at line 123, this is an incoming message from Craig to the defendant on October 1, in which he says, "That was good as fuck. I'll take that anytime. Friday. No, I made you come for a long time." And she responds in line 124, "I would be down to do that again anytime." And then she sends another response in line 125, "And yes, you did for a good ass minute." All right, so that's thing number one. They clearly make out a sexual relationship. thing number two is that there's some indications in here that there is a connection to Danny. On page 2 of the document, line 13, at the top, the defendant sends a message to Craig. Well, starting at line 12, Craig sends a message to her saying, you okay today? Your man here? And she responds in the next line, yeah, I'm okay. He's on his BS today, and I don't feel like arguing. So there's some of that in here that they're talking about Danny, and she's talking about it in a kind of frustrated tone. So we do think that these messages and the fact that this relationship are part and parcel of the Danny defendant status of the relationship kind of subject matter that has already been ruled admissible. They're sort of intertwined with that. And it's further intrinsic to that night because that's the guy who she was going to see and whose house she was at for 10 minutes. This is not just character assassination. It really does help tell the story. Okay. The other thing, and this is similar to the argument that I made for some of the Stingrays stuff the other day on Thursday, is that in the interview that comes next, they've seen these messages. And so they ask her, who's Craig? And she says, oh, that's Red, same guy. That's a drug dealer. This guy I saw that night. And they ask her point blank, is there anything going on between the two of you? Is there a sexual relationship? And she tells them no. Right, so she denies it. Again, even if she hadn't denied it, even if she had said, yeah, I think it's still admissible for the reasons that I've articulated to this point. But then the fact that she denies it makes it further irrelevant because she's charged with making numerous other false statements in the same interview. We have to prove that those statements were knowingly false. And part of that involves proving that she was lying up and down about basically everything she talked about that day. So that's why we think this evidence ought to come in. I understand that there is some prejudicial effect to it. However, the test is not whether there's some prejudicial effect. The test is whether the probative value of the evidence is substantially outweighed by the danger of unfair prejudice. And I just think that's a very difficult thing to say. You know, the rules are supposed to be rules of inclusion. Exclusion based on 403 grounds is characterized in the case law as an extraordinary remedy. And given that he was the guy that she went and saw that night.
I mean, I wouldn't want to be reading about Leilani's fluids either. Ew.
After this fight, and part of our case is saying that she was in this fraught emotional state. I just don't see how the court can say the probative value of this evidence is substantially outweighed by the danger of unfair prejudice. I mean, these are the facts of the case. These are the facts of that night. So that's our position on this evidence, Your Honor.
Thank you, Mr. Hilliard.
Your Honor, 24-403 states specifically, relevant evidence may be excluded if the probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Whether or not she had this affair, whether or not she was having sex with this person named Craig, bears no relevance to any of the issues in the case. I understand Mr. Dean wants it to be, but his argument that he just made was, well, she's charged with other false statements in the indictment, so the fact that she made false statements about having an affair means that she might make these other. That's propensity to commit a crime. Okay? It's exactly one of the reasons to exclude prejudicial evidence. So I understand why Mr. Dean wants it. I understand why he's asking for it. But that's the main reason to exclude it, not include it. So that's why we're making the motion in limine, Judge, and we leave it with the court.
All right. I'm going to take a moment to consider what you just presented. So let's take about a 15-minute break.
I mean, is it relevant? It's the night before. So the night before, or like, you know, they said it probably happened sometime in the middle of the night because Danny was sleeping, right? And she left that night? No. So the day before, the night before. Yeah, they've been on break since, so they're still on break. She needed a break to deal with that bullshit. Is it relevant? I don't know. That if her defense is because she was so distraught over Danny and she lost her mind and something happened to Quentin, then of course it's relevant. So, but I don't know. Relevant as fuck, she says. All right. So that morning. So if, let's say Quentin was killed at 1 a.m. She went and had sex with Red after or prior? She does love breaks. Oh my goodness gracious. She does. Yeah, I don't know what her defense is either. That I was lost on that part. I'm like, what the fuck's the defense on this? Does she have a defense? No, there's no defense here. But I don't know. Back for more. I'm clicking over back and forth between each of these. They're not back yet. Either one. Everybody's on a break right now. They're all on a break. They're all on a break. Hi, Lola. Hello, Loli. That's the name is Lulu Mama. You're so pretty. Yes. I think Red lives in the trailer park where, oh, good Lord in heaven, Jesus. Yeah, that's how she was paying her debt. I would assume. I mean, why else? Well, unless they just were having an affair. But if she's going to the drug dealer to get drugs, and then he's texting her about sex stuff, clearly, you know, that's how she's paying for it. Rumors and speculation. Every bit of it. It's all rumors, speculation. None of these things happened. Didn't happen. Which is such a bogus statement to make. Quentin is no longer here. Her phone tracks her going to these places. Come on. I mean, she lied about everything. She says her door was open and he was taken. Nobody took him but you, Leilani. Nobody. She's just a lying liar from Liarville is what she is. She cashed out Brett $80. Great. Great. Yeah, pretty much. Hey there. I mean, she looked really sad in that video too. It's all rumor, speculation, and we are going to prove it. There's no evidence. Thank you, Your Honor. That's it. Bye. That's the end of that. Goodbye. I mean, there is no defense. So what are you defending? There's no defense here. I mean, unless there is, and I don't know what it is. Sorry, I'm trying to open this package. Ooh, okay, that smells really good. Come on, people. People. Where are you? None of them are back yet. Long sidebar break. Yes, it's a long sidebar break. People call him Billy Joe, Billy Jaw. So ignorant. So ignorant. Yeah, Danny's testimony is going to be very interesting because he took off pretty much right away. He was like, oh, no, bitch. You're not going to get me caught up in this mess. Not today. And you can't blame him. I would have left too. Pop-Tarts, check. My goodness. Can you hear my dog snoring underneath me? Oh, goodness. Now I'm wondering, too, about the COVID with the attorneys, with the jurors. If one already tested positive and they were already sitting in there, I don't know if it's still the whole 6 foot. I have no idea anymore about the COVID stuff. I have to travel soon, so I don't want to think about that. And I don't even know what the newest COVID is like. I'm hearing different things. Let's see. Oh, geez, it has a whole new name. XEC. Okay. All right. It's a combo strain of KS11 and KP33. Let me see. Admission rate for patients testing positive for the new strain rose to 4.5 per 100,000 people in the week of October 6th. This strain is more transmissible due to its numerous mutations. Uh-oh. Tiredness, headaches, sore throat, high temperatures. Okay. High temp, aches, tiredness, sore throat. It's really all I'm seeing on this one. And this is across the UK that it's spreading, so I don't even know what's here. Has it even gotten here yet? Well, Yale says it did, so let's see. Big jump, blah, blah, blah. Okay. Will the 2024 updated vaccine protect against this one? Probably not. Okay. There's a bunch of different things going on with the kids around here. Tons of them. We're back.
You ready? We're back on the record. 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Kester on behalf of the state. William J. for the state.
Defense. Ms. Boone is still seated at counsel's table wearing the same gray suit and white blouse from this morning. Can you all approach?
Look at her. She's just happy, ain't she? She's like, thank you so much. I'd like to thank the Academy and Court TV and Law and Crime for covering my movie. Thank you. Sincerely. I dedicate this award to Beyonce. No, not Beyonce. Maybe to Diddy. Not Diddy either, though. Your daughter had it and slept for a week. Oh. Around here, it's been like a stomach bug, maybe, like vomiting and all the things, but a high fever, then no fever, aches, pains. So I wondered if it had something to do with that, but all the kids are getting tested and no COVID tests have come back positive, so everybody is confused. Yes, and especially to all my YouTube fans. Thank you so much. Is she fucking organizing the friggin' attorneys shit? Do you see her? Organizing all the things like ma'am? She probably is a very organized lady, I would say. But I think she thinks she's an attorney. Seriously. I think she thinks she's like an attorney. She's very serious, isn't she? Oh, did you just fucking roll your eyes at me, Sarah? I don't appreciate that at all. Did you see her? Oh, here go Lola and little mama fighting. Oh, it's Aries. Hi, Aries. Come here, buddy. How'd you get up here? Come here, my pumpkin. Lola, leave him alone, you evil monster. Come here, Aries. Aries. Leave him alone, Lola. He's an old man. Hi, buddy. I love you. Come here. Don't look at her. She's not going to do anything to you. Come here. Don't cry. Come here. Lola's so damn bad, y'all. Good Lord in heaven. Poor Aries, man. He can't even get in the room. Come here. Come here. Little mama, stop. The flowers is evil, I know. Poor Aries, he had to leave. You're such an ass, Lola. You know that? You're a real ass. I hope you're proud of yourself. Jesus, Christmas. Unbelievable. Here he comes again. He's going to try one more time, maybe. You ever have a dog who's like that? They're so tiny, they think they can whoop everybody's ass. I mean, she can, though, Lola. She's very tough. But she doesn't even allow other dogs near me. Except little mama who will whoop her ass. Oh, what's that little smile about? Did you see that? She looks perturbed. Maybe she found something in their notes that she didn't like. Yeah, I'm so sure. Like, oh, yeah. They come back to sit down. They're like, what the fuck's going on here? What happened to all our paperwork? And she's making notes all over everything. Did you see her? Like, what are you doing? Stop. She's so crazy. Oh, Sarah. I think this is going to be one of the most engaging trials that we've watched in a very long time. Because she is absolutely wackadoodles. She knows all the things and all the land. At least she's not a sovereign citizen like our friend Daryl. That would have been terrible.
All right, court's going to step out for 1 second,
Oh my
and
God.
then you can email that exhibit list to Madam Clerk, and then we can go from there. Thank you.
What? What? What are we doing? Court's gonna... Oh. I have no idea. I don't know what we're doing. Are we even coming back? Is it over? I don't know. The lawyer you know just posted. Defense reveals the overt act that put Sarah Boone in fear of serious bodily harm was George sticking his finger out of the suitcase. Oh my God. So there's a Sarah Boone parody account on Twitter. And it says, does everybody love that James and I dressed matchy-matchy today? Do we not look like a power couple? I can't. Look at this. I recommend watching this podcast, Real-Time Updates. They talk about me consistently. I can't do it all myself. I'm busy chatting up my dream team and thinking about myself. Checkout today only. Oh no, bitch. It's suitcases. What are you, crazy? No. Lunch with James alone. I'm going to ask. If you don't ask, you'll never know. Shoes make a girl. True. Addressing questions about why so many alternates. We need to have enough to replace the ones we find out are there to ride my fame. James told me if I write one letter, he's off my case, so I'm doodling notes for my New York #1 bestseller. Best I can do right now. Oh, I can smell cigarettes on some of the jurors as they walk by. My days of freedom are near. The official lemmings will be picked tomorrow. Let's hope they're smart enough to understand my case. Oh my God. Today is War Deer Day. Sorry, guys, you don't get to watch, but my freedom is finally on the way. Liquor store, here I come. Oh my God. Getting ready for my appearance at 3 p.m. I've got cherry Kool-Aid on my lips and Vaseline on my eyelashes. Let's go. Oh my God. They said I couldn't have a lawyer, but I excel at everything, so now I have 3. Oh, I can't. If Karen Reed received a bond, I know I keep talking about bonds, and it's late in the game, but it's a hill I will die on. Oh my God. Oh, she's in love. Yeah, I can't. Sheesh. She's gonna sue the lemmings. Can't. Oh, this was one of her things. Yeah. Inmate seeks attorney. I just can't. Oh, I can't, Sarah. Oh, geez. How did she know? See, people do see me as a hero, just so many fans. I don't know. The whole Richard Allen thing, what are we thinking? It's very upsetting. It's very upsetting. I know Gray thinks everybody who thinks it's a thing is crazy and stupid, but I think it's a thing. I think we're done for today. They have to get back to jury selection, right? I don't know. I don't know. I think. I mean, and then just keep up on Twitter. Or I think Trial TV is also covering. Let's see. Let me see. Let me look. I'm a really good waiter, as you can tell. Like, I love waiting for things. Can you tell? It's my favorite thing to do. Let me look. Aries, don't cry. Just come over here, buddy. Gosh, don't let her make you cry. She's so fresh. Jeez Louise. No, he's covering Leilani. Okay. Defense diaries. They're crazy. I don't see anybody coming back. Nobody's coming back. They're just sitting here doing shit. So if anything else happens, I will post it on my community wall, or there are like 45 other people covering this today. Law and Crime clearly is covering it. I believe Michelle Walks had it on for a little while. La, la, la. I'm subscribed to way too many court channels. This is kind of ridiculous at this point. Because if they don't get through the jury stuff today, they're going to have to do it tomorrow. Then the trial won't start till Friday. So until then, just keep up with the community wall. And I will see you guys soon, okay? I love you. All right, bye.